Hey everybody, this is Jason McGrath. This is another segment of Carolina Contracts. And we started this series talking about arbitration clauses that you might have in a contract. And so one of the issues you come across really frequently if you're involved in contractual disputes, which I am, is how do you end up in arbitration versus in court? And so what typically happens is that somebody that has the dispute, with this contract is going to decide, do we follow the contractual provision and actually just start an arbitration, which by the way, you can do without actually filing a full lawsuit? Or am I just going to file a lawsuit even though the contract says that we're going to arbitrate all of these disputes? And, quite honestly, I see more often than seen an arbitration just start without a full case lawsuit filed, that the contract may require it to go that way. What I see more often is that one of the parties goes and files a formal lawsuit as if there was no arbitration clause in the contract. And sometimes there doesn't appear to be a real good reason for that. It's just sort of the way it is. And there can be some negatives and some penalties if you do disregard the arbitration clause and go ahead and file a full formal lawsuit despite the existence of that arbitration clause. So if you're in a dispute and you're considering bringing some kind of legal or quasi-legal action, take a look at the contract and see if it does in fact require arbitration. If it does, you need to talk to your attorney about whether you go ahead and just initiate the arbitration. Hopefully your attorney knows how to actually do that. That would be a good start. Or if you're going to file a full lawsuit. And just make sure you're making a carefully considered and informed decision, because again, there are pros and cons with both of those choices, and you want to be aware of those so you're making an intelligent decision that doesn't backfire on you later. All right, be mindful of that. Thanks.